We will now be beginning with the second. Come inside and resume their seats.
People outside may not be able to hear.
Good morning, ladies and gentlemen. Welcome to the second session of the Delhi Arbitration Weekend. The subject of the second session is the 2025 SIAC rules, charting a new course in international arbitration. These new 2025 Singapore International Arbitration Center rules have been promulgated after extensive global consultation which involved diverse stakeholder feedback with a view to promoting efficiency, transparency, and procedural flexibility in the arbitration process at the Singapore International Arbitration Center. There are key reforms that have been brought about in these rules, which include the emergency arbitration process by permitting ex parte protective preliminary orders, new rules and streamlined procedures for low-value disputes, the codification of rules for coordinated proceedings for related disputes, mandatory disclosure for third-party funding, and detailed procedures for preliminary determination to expedite dispute resolution processes. These are some of the key issues that have been highlighted in these new rules, which will needlessly be discussed in the panel. The chair of the panel is one of the most illustrious judges of our Supreme Court, Mr. Justice L. Nageswara, who had the rare distinction of being appointed from the bar to the Supreme Court of India. He is the author of over 248 landmark judgments that shaped modern law across commercialities in arbitration. He brings vast experience from both institutional and party-nominated cases, spanning complex international treaty-based arbitrations, domestic disputes in construction, energy, and corporate and sports law. Justice Nageswara is also a part of the 39 Essex Street Chambers. We also have Ms. Lucy Reed, who is the president of the Singapore International Arbitration Center Court and a leading global arbitrator with extensive experience in investor state and complex commercial disputes. She has served as arbitrator in over 65 major cases previously led Freshfield's worldwide arbitration practice and held prominent roles in the ICCA and other international institutions. Ms. Reed is also recognized for her scholarly work and contributions to legal education in arbitration. We also have Mr. Sudhanshu Swaroop, KC, who is a leading silk with an expertise in arbitration, commercial and public international law. Known for his precise legal drafting and strategic acumen, he has acted in landmark cases such as representing the Republic of India in the enforcement of an investment treaty award of over US dollars 100 million in the Davis Mauritius case. Highly regarded for his clear advocacy, Mr. Swaroop has extensive experience in handling complex disputes involving state immunity, climate change, and international arbitration. We then have Mr. Prantap Kalra, who is the General Counsel for India and South Asia at JCB and has previously served as the General Counsel at Nissan Motor Corporation, overseeing legal compliance and secretarial functions across the region. With over 2 decades of diverse legal experience, he has played a pivotal role in managing complex regulatory and litigation risks within the automotive sector and beyond. Recognized for his strategic leadership, Prantap has successfully driven multiple innovations and contributed significantly to corporate legal governance and risk management. We have Ms. Kapoor, a partner at Shardul, Amarchand, Mangaldas, specializing in international domestic arbitration and commercial litigation with extensive experience across sectors including energy, infrastructure, healthcare, telecommunications, and hospitality. She is qualified to practice in India and New York and has represented clients in arbitrations under various institutional rules such as ICSID, ICC, ICDR, amongst others. She is recognized as a global leader by Who's Who Legal and ranked by Chambers and Forbes India. Ila is an active member of several illegal bodies and the SIAC, where she serves as a member of the Court of Arbitration. I hand over the discussion to Justice Rao to take it forward. Thank you.
Good afternoon, ladies and gentlemen. So just before I started, 3 of my colleagues asked me whether they can come for the conference. I told them that I've been informed by lawyers that they are not able to get confirmation for registration. There appears to be a mad rush. The entire world is here. I'm surprised to see so many vacant seats here. especially for such an interesting session on SIAC rules where you have the president of the SIAC and others who are going to share their views on the new rules of 2025. I thought the hall would be full. Anyhow, so we start off this session by my reminding all of you that international arbitration is resorted to by users because of its speed and economy and also flexibility, apart from several other factors. In recent times, there has been some simmering discontentment on these aspects as people were thinking that the speed and economy are factors which are really becoming a problem insofar as users of arbitration are concerned. The SIAC was formed in 1991, and over a period of about 34 years, it has made great strides, and it has also remarkable performance has been shown by SIAC as an international arbitration center over the past 25-30 years. In the QIAUL survey that is done by Queen Mary's and White & Case in 2025, Singapore is the second most preferred arbitration after London, having about 30% of the work. And the most preferred rules are about 5, and one of them is SIAC, other than ICC, Hong Kong International Arbitration Center, LCIA, and the UNCITRAL rules. The 7th edition of the rules came by way of an amendment that was made in 2025, and the 2025 rules would be applicable to all arbitrations that have commenced after 1st of January 2025. Emergency arbitration, which you would be hearing for most of the time during this session, was initially started by the AAA ICDR, and SIAC in 2010 introduced emergency arbitration for the first time in 2010. SIAC has also issued investment arbitration rules in 2017, and it is the only private international arbitration center which have separate rules for commercial arbitration and investment arbitration. Without my going into the amendments that have been made by the 2025 rules, I would ask the speakers to share their views on certain aspects which I would be asking questions upon. And I would be summing up the session after you hear all of them on the rules that are made. First, turning to Lucy, who is the president of the SIAC. Lucy, can you tell us the historical background, the reasons for the 2025 rules, and the process that was adopted in making the rules?
Thank you, Justice Rao, and thank you all for being here. I'm happy to address that question. I have the benefit of this morning hearing from our SIAC registrar, Vivek Nilakantan, who described the SIAC as follows. He said the people, the staff, our outreach activities are kind of like a business card. It's the outward facing, but the software for SIAC is the rules. And like any software, it is important to update the software when necessary. And for us, updating of the rules is triggered by user demand and by changes in the marketplace. Basically, no institution wants to change its rules too often because then it's hard for the users to keep up, but often enough to stay current. And I think it's safe to say that while I have very positive things to say about every major arbitral institution, SIAC has led in rules innovations. And taking you back in time for a few minutes, in 2010, SIAC issued its 4th edition of rules, and the main innovations were emergency arbitration, which AAA had done before, and a 6-month expedited procedure. In 2014, the next edition, the big change was to promote arbitration, mediation, arbitration, or ARB-MED-ARB process, working with the sister organization of the Singapore International Mediation Center. And then before 2025, the last amendments were in 2016, where the major innovations were a very well beta-tested set of rules for multi-party arbitrations with a focus on consolidation and joinder, and also to put in writing the availability of an early dismissal for arbitral tribunals. Now, so that 2016 was 9 years ago, and I would say probably the day after the 2016 rules were put in print, we started keeping a file of changes to think about in future. And at SIAC, the Secretariat and the court have the benefit of case management experience. We had more than 3,000 international cases filed under the 2016 rules to serve as the lessons, if you will, for the amendments. We had parties from 100 jurisdictions across a range of seats and governing laws. And I also heard this morning confirmation that of SIAC's overall work caseload over the years, we've had 2,400 Indian parties and 1,400 Indian party cases. So a lot of the focus as the rules were prepared was on experience from and involving India. Now, the process was as follows. The drafting of a set of amended rules was done by the Secretariat. A lot of internal review and discussions leading to a full draft, which was put out for extensive public consultation over a several-month-long period out to users and other stakeholders, including access to the SIAC users' councils in several countries. Reached out to practitioners, arbitrators, and in-house counsel as well, and to government representatives and academics. The Secretariat collated the comments, which were extensive. It was almost like an old-fashioned telephone book for me to go through all the comments on the proposed amendments. And then we worked closely with our court, which has about 40 members of several nationalities. And we convened, we collected written comments from the court members in advance. And then a year ago, we had a whole day court session where under my guided leadership, we broke the court members into committees and assigned the most important amendments to each committee to debate amongst themselves and then come back for a discussion. And there's surprising difference of opinion on some of the proposed amendments, which I'll come back to later. And only at that point did we finalize the 2025 rules and issue them.
Yeah, that gives us the big picture about the rules and the process that was followed before making the rules. May I turn to Sudhanshu? Sudhanshu, emergency arbitration is significant in this 2025 rules with all these refinements of timelines and processes. How do you compare them with the global trend of strengthening emergency relief?
Thank you, Judge Rao. First, it's a real pleasure to be back here in Delhi and to see the city looking so green and pretty in this lovely September weather. So first, I just want to start by outlining what exactly is the change that has been made in the 2025 SIAC rules in relation to emergency arbitration. The previous version, the 2016 rules, contained a provision for emergency arbitration. The SIAC was obliged to appoint an emergency arbitrator within 1 day of receiving an application for the appointment. The emergency arbitrator then had 14 days to receive submissions from the parties and to provide the emergency decision. And there was express provision within the 2016 rules for the emergency arbitrator to grant relief not only in the emergency decision, i.e. after 14 days, but also in the intervening period of the emergency arbitration during the 14 days. Specifically, the 2016 rules provided that, quote, the emergency arbitrator shall have the power to order or award any interim relief that he deems necessary, including preliminary orders that may be made pending any hearing. In other words, there was a power to preserve the status quo, to hold the ring during the 14 days until the emergency decision. The 2025 rules keeps and develops the regime for emergency arbitration. It keeps the power, preserves and develops the power for the arbitrator, the emergency arbitrator, to give a preliminary order directing a party not to frustrate the purpose of the emergency interim relief. But critically, it allows that initial preliminary order to be made on an ex parte basis. And that's the real innovation in these rules. So the regime, in summary, is as follows. A party can, without notifying the other side, file an application for an emergency arbitrator, requesting the ultimate interim emergency award, together with an application for a preliminary order. The president of SIAC can then appoint the emergency arbitrator within 24 hours. The emergency arbitrator then has 24 hours to determine the preliminary order application. So it's a very, very rapid timeline. Then upon that order, within 24 hours, within a further 12 hours, the applicant must deliver to the other parties a copy of the case papers that have been filed together with the arbitrator's order and all communications between the applicant and the emergency arbitrator. And there is then the full 14 days from the appointment of the arbitrator for the completion of the emergency decision. So against that background, looking at the more international context, I've got the following comments. First, the original regime in the 2016 rules providing for emergency arbitrators, that in itself is reflected in a number of other arbitral rules of the time and subsequently. Secondly, the express power you saw in the 2016 rules, which allowed the emergency arbitrator to issue a form of status quo order, the preliminary protective order, that was more innovative and has been reflected in more recent updates to other rules. So, for example, the HKIAC rules of 2024 include not just a regime for emergency arbitration, but an express power for the emergency arbitrator to issue a status quo order. Thirdly, the 2025 SIAC rules, which provides for the status quo order to be made on an ex parte basis. Now that, as far as I'm aware, is unique to SIAC. That is genuinely an innovation that has not yet been reflected in other rules. So, for example, the LCIA rules, Article 9b, there is a regime for emergency arbitration, but nothing in express terms like this ex parte provision. Fourth, there is an issue about the enforceability of these kind of ex parte orders. This is an area where I don't think there is a clear answer, and there's no international consensus yet. So there is a risk that these ex parte orders will be made by emergency arbitrators under the SIAC rules, but they will not be enforceable because it will be said they violate due process. But that said, there is a provision under this new SIAC regime for the moment the emergency in a preliminary order is made, for the other side then to be notified and to have a right to present its case. So a subsequent modification of that order may not fall foul of enforceability. And fifthly, and finally, I just want to make a comparison with the UK rules. So as some of you may know, in 2025, this year, the UK has passed the new Arbitration Act, which amends various aspects of our 1996 Act regime. And one of the amendments concerns emergency arbitration. And in summary, the new Act says this: where the parties have agreed to an existing set of institutional rules that allows for emergency arbitrators, then, and if an emergency arbitrator is appointed, then, quote, if without showing sufficient cause, a party fails to comply with any order or direction of the emergency arbitrator, that emergency arbitrator may make a peremptory order to the same effect, prescribing such time for compliance with it as the emergency arbitrator considers appropriate. And furthermore, the court may then make an order requiring a party to comply with a peremptory order made by the tribunal or made by an emergency arbitrator. So this is innovative, because in our 1996 Act, there was no reference at all to emergency arbitration. The concept was not really known or recognized. The 25 Act recognizes the concept of emergency arbitration, expressly empowers emergency arbitrators to make peremptory orders, and critically expressly empowers the court to enforce the order of a peremptory, to enforce such a peremptory order as if it was an order of the court. So these are all new and very important innovations. What is not yet clear, though, is whether an ex parte order of the kind that SIAC contemplates, how that would be treated under the new UK regime. So that's everything I have to say.
Thank you, Sudhanshu. We will speak about the enforceability when I ask Hila about the PPO says and when we go to the next session. But see, we have spoken about emergency arbitration and what is a global perspective, as I shared by Sudhanshu. Hila, now under the 2025 rules, there is a timeline that is fixed for delivery of awards, which was not there earlier in the 2016 rules. And even the grounds for challenge of an arbitrator have been expanded in the 2025 rules. But do you believe that these would strike a right balance between quality and efficiency?
Thank you, sir. So indeed, there are new timelines which the SIAC 2025 rules have included for tribunals rendering an award. And while it might seem that they've actually increased the time for which a tribunal increases their award from 45 to 90 days, what they've done is, in fact, in the earlier rules, the tribunal had 45 days to give their award after closing. But what we did find as practitioners that tribunals didn't close inexplicably for months after the last hearing. And then they would suddenly close and we'd get the award. So what the new rules does now is says that after the last directed submission, the tribunal has to, within 30 days, inform the parties and the court, the registrar, when will they give the award, and within 60 days they have to give the award, they have to pronounce it. So if you consider that it takes 5 to 6 weeks for scrutiny of the award, SIAC is now promising that we should have an award from the tribunal within 5 to 6 months of the last hearing date, which is quite quick. And we've all had situations where we've been waiting for awards for a long time, so it certainly increases certainty here. The new rules also increase expedited proceedings, which were earlier within a limit of 6 million, and now the threshold has been increased to 10 million. So an expedited proceeding has to be finished within 6 months from the constitution of the tribunal. And there's a new process which the 2025 rules have included, which include the streamlined process. Now this is for very few arbitrations which are only under $1 million value limit, but the tribunal has to pass the award within 3 months. Now, clearly, there's going to be no discovery process and no cross-examination. It's going to be based only on the evidence as submitted with the pleadings. So SIAC in its 2025 rule seems to be tightening the timelines for tribunals to deliver. And I think, as Lucy said, there was an effort to deal with the demand from parties that they wanted more certainty. And another way that they have increased certainty is they've included a ground for challenging an arbitrator on incapacity of the arbitrator. So they specifically say de jure or de facto incapacity. And this is inability of the arbitrator to perform. This is obviously in addition to the earlier grounds of challenge, which was he was unfair or biased, etc. And it's an interesting addition. Actually, the Indian Arbitration Act already had this provision in Section 14, I think, where we said that if the arbitrator was incapable of completing their process, wait, let me read it out, which provides that the mandate of the arbitrator shall terminate and he shall be substituted by another arbitrator if he becomes de jure or de facto unable to perform. So the Indian Arbitration Act already had this provision. And it's interesting to see how SIAC will interpret de jure de facto inability, because in the Indian case law, it's been interpreted by judgments to mean if you don't have enough time to really complete it in the case, your case management. We have Indian case law which says that if an arbitrator doesn't have a visa for the seat of the arbitration, he's incapable of performing it, he should be replaced. Basic unavailability. And as a counsel in many of these matters, I look forward to this, because what we find is that if for any reason the tribunal misses, we have an adjournment and a hearing has to be rescheduled, we're looking at 1 more year before 3 very esteemed tribunal members can match their diaries and give us another date. So there's the hope that people, when they accept these appointments, are going to be conscious of this clause. So again, SIAC's efforts to speak to users' demand, asking for more certainty in the arbitral process.
Thank you. Predictability is just as critical as efficiency. And you as an in-house counsel, Prantap, what do you think about the introduction of early dismissal and preliminary determination in the 2025 rules?
Thank you, Justice. Good morning, everyone. I think it's very important, one aspect to understand as the disputing party or their representatives as in-house counsel. Sometimes there's a tendency to ask everything under the sun. And that's how the discussions internally at times start. And then with the interventions from the external counsels, it becomes very important to separate the wheat from the shaft, so to say. And I think the preliminary determination and the early dismissal process brings in some of those checks and balances which, as disputing parties or in-house counsels, will have to factor in, because there are mechanisms where an application can be made for determination of specific issues if they're not in the interest of time and costs, etc. There is a time-bound mechanism now also for early determination. I think it's 90 days, subject to, of course, extension. And for preliminary determination, it is about, 90 days, for preliminary determination, and 45 days for early dismissal. The broader point is that the disputing parties who really are bringing the dispute, are you sensing it from your perspective that taking the dispute to the SIAC or any other arbitration center will bring out the resolution and the orders in time, and will they be effective? I think there are now clear criteria, as we said, manifestly lacking legal merit or jurisdiction is one of those grounds as well. The efficiency will be realized with the swiftness of the process, of course. And I think this will enable the tribunal and the parties to focus more on truly contentious issues and claims, rather than making everything under the sun. The predictability, in my view, I think comes from these clarities, and also to protect parties' right, where the parties are sure that the fairness and the transparency of the process remains, and therefore there are safeguards in the system and in the process which will ensure that the orders are still fair. overall, if I have to sum it up from an in-house perspective, I think I would say that we now have wider grounds, of course, more clearer and more predictable process with these two sets of rules being in place. A more defined and accelerated timelines, I would definitely use accelerated considering the number of days that are given for these. And with the increased use of technology that we are seeing in the new rules, I think it'll become very efficient and very effective to get the disputes resolved and the orders passed quickly, which will definitely help any disputing party and also us as in-house counsels to be able to drive more value for our organizations to showcase that, yes, disputes, while raised, do not take too long to be concluded. The orders come in, and of course, there will be an appeal procedure which can follow it in due course. But there is definitiveness in both these processes of preliminary determination and early dismissal, which should help us all. Thank you, sir.
In every international arbitration conference this year, the talking point is the SIAC amendment to the arbitration rules in 2025. And whatever discussions were there in those conferences which I was present, the focus is on the protective preliminary orders, which have been introduced in 2025. Let's turn to this protective preliminary order, and I'll ask Sudhanshu as to what is the scope of these protective preliminary orders. Though you have touched upon this, can you just tell us about the scope of these rules?
Yes. Thank you. I've outlined the procedure for these rules, but I just want to respond to your question, going back to the question of procedure and then also looking at the substance. So, as regards to procedure, the essence of this preliminary order is that a party can apply at the same time as they apply for their emergency arbitrator, and within 24 hours of the appointment of the emergency arbitrator, there is an obligation on the emergency arbitrator to deliver the preliminary order. And that order is then transmitted to the parties. Within 12 hours of the transmission, all documents, case file, and so on have to be given to the other side. The critical feature, as I say, is that until the preliminary order is made, everything is ex parte. So just in terms of procedure, and in answering to the question of scope, the point I want to emphasize is the safeguards that exist as given the ex parte nature of the procedure. And the safeguards are these. First, as I say, the party against whom the preliminary order has been made must be given access to all case documents within 12 hours of the order being made. Secondly, the emergency arbitrator has to provide that other party with an opportunity to present their case at the earliest possible time. Thirdly, the emergency arbitrator must promptly decide any objection to a preliminary order. And fourthly, in any event, the preliminary order expires within 14 days of issuance, the idea being that at the point of the 14 days, the ultimate emergency decision then takes over and governs. So in terms of the procedural scope, that's what I want to say. In terms of the substantive scope, the relevant part of the new SIAC rules, the schedule to the rules which deals with this procedure, since they're very broad, they simply say, as regards the preliminary order, the emergency arbitrator may consider a request for an interim measure together with, quote, an application for a preliminary order directing a party not to frustrate the purpose of the emergency interim or conservatory order. So the obvious example that comes to mind might be to preserve assets, so something like a freezing order. Another example might be to preserve evidence, to preserve documents pending the ultimate decision. And one can immediately see the good sense of all of this and the need for all of this, because so often the very circumstances, the very urgency that compels the need for an emergency arbitrator also means, at least at the outset, some sort of order needs to be made without giving notice to the other side, because the very act of giving notice will defeat the very purpose of the emergency arbitration procedure. And of course, a freezing order is the paradigm example of such a situation where notice will defeat the purpose of what you're seeking.
Thank you. What are your views on the PPOs, Ila? And I also wanted to ask for your reaction about the enforceability of the PPOs in India. Sudhanshu was mentioning about the enforceability.
Yes, thank you. Actually, the first thing I thought about when the PPOs came out is, does this replace, and with my counsel hat, does this replace my Section 9 application in court to go immediately and get a relief the very next day, right? Is it going to be as powerful as that? Because as Indian lawyers, that's what we do. First, we get the interim relief, then we start thinking about what's next. But the point is, it's not enforceable, certainly not in India. In fact, emergency awards which are from a foreign seat are also not enforceable in India. We know that, that there is a provision in the draft new arbitration rules that allows for emergency relief from India-seated arbitrations to be enforced. So PPO orders right now face a problem of enforceability. The question is, who is the order going to be against? If it's just against the party who's going to be in the arbitration, they are going to likely follow it and not piss off the tribunal. So you can do it. So it's a question of what is the relief you want and what is the relief that you can get. But interestingly, it'll be the courts that push it, because I was telling you, Lucy, that we were in Singapore and we wanted to get an interim relief from the court there, and our co-counsel in Singapore said, if you go to the Singapore court for this, they are going to say, go for the PPO order. And if they, why are you coming to us? The same thing will happen, I have no doubt, over time. The Indian courts will say, don't come here in a Section 9. At some point when this gets regularized, and they'll say, why don't you go? They have started doing that now with emergency relief. Even though emergency awards are not recognized in India, we have judges who have told us, why are you coming in a Section 9? The other side will say, it's a SIAC provision, please go and get emergency award. And it's a great thing if it comes to that. It will certainly take the burden off some of the court applications on this.
A slight difference between an India-seated arbitration and an arbitration where the seat is outside India in respect of emergency awards being enforceable. According to Amazon, Indian-seated arbitrations, emergency awards are enforceable, which is not the case with an emergency award that is passed in Singapore. Let us take Singapore. So the debate that has been going on is regarding the enforceability of a protective preliminary order, which is an order that is passed without issuing notice to the other party. The Arbitration Act itself speaks of no such power being conferred on the arbitrators. And as Ila says, there is a doubt as to whether a preliminary protective order can be enforced in India. I would just ask Lucy as to how the emergency arbitrations and PPOs been working out.
Thank you, sir. I'm happy to give some statistics and color to this. In terms of what I'll call regular, not PPO, but regular emergency arbitrator statistics, in 2024, there were 21 applications at SIAC for over the whole year for emergency relief, and all were, the application was accepted. By that I mean, under our rules, when a party files a notice for arbitration and an emergency arbitration application, it goes to the president to decide if it's really an emergency. If I have to clear conflicts before I see the matter, and the then emergency arbitrator will be appointed, and the arbitrator will decide whether the emergency merits relief or not. So of the 21 applications filed in 2024, I, or a vice president, accepted all the applications to go forward to an emergency arbitrator. Between 2010 and 2024, there were a total of 173 applications, all accepted. Why is that? Because our view is that it's best for the emergency arbitrator himself or herself to assess the emergency nature of the application. Now, interestingly, for the first time ever in early 2025, I rejected an application for emergency arbitrator appointment, and both parties were Indian parties, by the way. And the application was rejected because there was just not even a scintilla of evidence that it was a true emergency. The claimants were seeking interim relief to preserve a status quo without suggesting that the respondents were likely to take any action at all that would potentially alter the status quo. So that changed our statistics. I asked as well for statistics overall, and I'm told that of the emergency arbitrator cases involving Indian parties from 2011 to 2024, there were 53 cases. That's 30% actually of the emergency arbitrator caseload. Now, in terms of the outcome of emergency arbitration, some injunctions are granted, interim relief is granted, and some is denied. We see everything. Just as an anecdote of how fast we do this at SIAC, when I landed from New York in Mumbai at 11:30 at night on Monday night, I checked my email and the Secretariat had sent me an emergency arbitration application. I cleared conflicts first, and then I read the case briefing form, and at the end of every case briefing form that comes to me in such an instance, the Secretariat will have already cleared conflicts with 4 to 5 potential emergency arbitrators, or started the process. So of the list of 4, they had contacted 2, had already cleared conflicts, 2 were pending, and within 15 minutes, we had the emergency arbitrator up and going before midnight on Monday night. So it's really, really fast, I would say. Now, PPOs, you've heard a lot about preliminary protective orders. This was the topic of the proposed amendments that led to the most discussion and different views among court members and out in the public. And I think it's disproportionate to what a PPO really is for. Why so much discussion? Because on the one hand, arbitration is consensual. And if you have something that's ex parte, you obviously don't have the consent of both parties to the process or the relief. But on the other hand, there are sometimes situations where if one party notifies the other party of what it doesn't want to happen, it will certainly happen. The ship will leave the port with the cargo, the bank account will be emptied. So there's a legitimate, rare but legitimate user need to have ex parte protection. Now, I will say that I'm not so convinced, Ila, that the Singapore courts will so often tell parties seeking temporary restraining orders to use PPOs as much as they do for emergency arbitration relief, because a PPO is really giving you moral suasion. You only are going to ask for a PPO if you want the parties to behave in a certain way. If you really need enforcement, you will go to court. And I remember Quentin Lowe told me a few weeks ago, he said, how many emergency arbitrator applications anyway does SIAC get? And I said, 20 in a year. He said, we get 50 in a week. So the courts are there to deal with things. Now, statistics. We have had 2 applications in 2025 for PPO relief. One was accepted by the emergency arbitrator and one was not. In the case where it was accepted, the claimant was from a Southeast Asian country and the respondent was an American. And interestingly, the emergency application and PPO application, which come in together, obviously, was made by the respondent in the arbitration, not a new claimant. And that dispute arose out of a settlement agreement between the 2 parties. And the respondent filed the applications to prevent the claimant from initiating court proceedings in multiple jurisdictions, which were ready to be filed, and breaching confidentiality obligations. And the respondent also argued that the claimant was threatening to publicize sensitive information in breach of those confidentiality obligations to put commercial pressure on the respondent of pressure of reputational harm. So no third-party relief involved. It was strictly between the two parties. And that case went on to the normal emergency arbitration process. So there was no issue of whether the PPO had to be enforced. How about the one that was rejected? That was a Chinese claimant and a Singaporean respondent, and the dispute arose out of a distribution agreement, and the claimant was seeking this PPO interim relief to prevent the respondent from disposing of certain equipment and threatening to allow the appointment of an independent party to take custody of the relevant equipment and get records. The claimant also wanted to get records from the respondent. The emergency arbitrator denied PPO relief because he just didn't see a truly urgent need for that kind of relief, because it wasn't a situation in which the respondent was going to act over the next 12 to 24 hours, or if it was forewarned that relief involving this equipment would be necessary. So that is the update on PPOs to date. I wouldn't lose any sleep yet over PPOs.
Thank you. With the hard timelines that are given to you, I think the president of SIAC and others responsible spent sleepless nights over this PPOs, though the number is less. If the number increases, we do not know. Ila, insofar as these 2025 rules are concerned, the SIAC's toolkit for multi-contract disputes with joinder, consolidation, and new coordinated proceedings have been expanded. How transformative is this for complex projects like Indian EPC cases, and what practical limits do you see?
Indian EPC contracts, as I'm sure many of us are familiar with, are very large and wieldy with multiple parties. There's contractors, subcontractors, financiers, suppliers, all sorts of things. And then when the dispute breaks down, everybody has a claim against everybody else, and we end up in different tribunals. Very often the clauses may not mirror each other, so it's possible that some have chosen SIAC, some have chosen another institution. So therefore, it's interesting to see how the SIAC rules will affect these kind of multi-party, multi-transaction disputes. The SIAC already had consolidation and joinder in their toolkit for these sorts of multi-party disputes. Consolidation, of course, allows multiple arbitrations to be merged into a single proceeding. All the parties have to agree, or there has to be a single arbitration agreement covering all the claims, counterclaims, and cross-claims. Now, joinder is when you have a new party who's added to an existing proceeding. That is a situation where that new party is either a party to the agreement, or all the parties agree to have this person joined to the arbitration as a relevant party. Now, the 2025 rules introduce a new concept called coordinated proceeding. And this allows a single tribunal hearing separate arbitrations that share common legal or factual issues to order concurrent or sequential hearings, joint procedures, suspensions, to basically align the resolution of these interdependent disputes. So everybody will get a separate award, but the tribunal will ensure that the procedures run on the same track so that there is some sort of holistic approach that the tribunal is able to get from hearing all of these disputes. Now, how will it impact not just Indian EPC contracts, but several multi-party disputes? It leads to some harmony in the decision-making, less inconsistency. Just to give you a practical example, we won some years ago an arbitration award. We were the contractor on a project, and the owner sued us for inadequate work, etc. We won that claim, and we then tried to enforce it in the Bombay High Court. And during the challenge proceedings, the other side produced, I wasn't the lawyer in that matter, but the other side produced evidence to show that my client had sued the subcontractor also for the same irregularities in the construction work, thereby admitting to the fact that there were irregularities. And that challenge is still pending. So what happens in this kind of a harmonization, which the SIAC's new coordinated procedure or consolidation, is that you're going to have less inconsistent decision makings of that nature. Now, there are some practical limits on the new coordination approach, which is that logistically, everyone have to have agreed on having the same tribunal. I'm not sure, Lucy, how practical that is. Everyone has to be on board with that. And the clause has to somewhat be similar. Unlike consolidation, it doesn't have to be identical, but it has to be, I think you have to choose SIAC for sure. You can't have a different institution. So those are some of the practical difficulties. I mean, these things, I think that this would be a very useful procedure in things like standard form contracts. So you have a bank which is given out a form, and it's got several users who want to arbitrate. So it's a similar factual question. Then this is an ideal situation where you can have the same tribunal deciding it. Another limitation I can think of is sometimes consolidation, coordination works out for some of the parties in terms of saving cost and time, but maybe someone had a smaller, cheaper claim, and now that person is going to have to be tagged along with the more expensive, larger project. So those are some of the practical limitations to this, but all in all, it's certainly something, given the climate and the way that multi-party international commerce works, it's something that we do need.
Yes, Lucy, you want to come?
If I can just add to that, so far this isn't being used very often, and I don't think it will be used very often because either most cases should be consolidated or not, but we do have a pair of cases proceeding now which couldn't be consolidated, but they're under the same tribunal and they fit the bill. And last night I was faced with an interesting decision I had to make, which is the claimant in one of the two cases has asked the case to be expedited, to be done under the 6-month process, but not in the second case. And one's first reaction is no, they should both be expedited if one is going to be expedited. But actually, if you think twice, because this combined procedure doesn't have to, the two cases don't have to be in exact parallel, they can be sequential. So if there's a reason to do one first that might help development of the second, then it should be done. So we've decided that to accept the application for expedited procedure for one case, and maybe that will lead the second case. And I think the same would be true, Ela, if it's a small, a baby case and a big case. Maybe you do the baby case first, and it helps with settlement of the second.
Thank you. Prantap, the 2025 rules introduced third-party funding disclosure. So how do you think this is going to shape arbitral practice in future?
So, thank you, sir. I think so. Third-party funding disclosure is very important. I think, and it heightens the transparency in the system. It's been made mandatory, and it's not just the third-party funding disclosure. It's also the identity of the funder, and in some scenarios, possibly the arrangement as well. I think this will bring added scenario of not just bolstering the confidence that exists in the process per se, but I think it'll fortify the positioning also for SIAC, wherein the integrity cannot be questioned and should not be questioned. I think that's my first point on transparency and integrity. The second is, of course, about conflict of interest, because if there is disclosure about third-party funding and third-party funders, I think there is also a good chance that the conflict checks can be done prior, before the tribunal is even constituted, or if there is required. That helps prevent any kind of future claims of impartiality or independence challenges that is a possibility later if these disclosures do not exist. I think the third part would be more on strategic and practical implication of this from a disputing party perspective, wherein the parties will have to get down probably on a better understanding on what's the cost, what's the security of the costs, and what kind of arrangements really need to be structured and should be structured, keeping in mind the institution that they're planning to approach. I think that's very important, and that brings everything on the table for the disputing parties and the businesses to understand that the value of transparency and not being in conflict is now also equally paramount in the procedure, and that has to be respected by the disputing parties as well. Those are my 3 points.
Sudhanshu, can you tell us about any analogous provision in the LCA rules and the scope of the provision?
Yes. So under the LCIA rules, there is simply no obligation to disclose third-party funding, nor is there any obligation to disclose third-party funding under the 1996 English Arbitration Act. And furthermore, in a case called Arroyo and others v. BP Exploration Co. Colombia Limited, the English court ruled there is in general no rule for disclosure of third-party funding arrangements in court proceedings in England. And there the court stated, quote, in privately funded litigation, there is no obligation on either party to disclose how a case is being funded. So that's the basic position. As I mentioned, we've just had a new 2025 Arbitration Act, but even that new act says nothing about disclosure of third-party funding. There's been quite a lot of commentary on this, with some people saying this is a surprising omission from the act, not just because there are the general concerns around conflict of interest and transparency, but also because our Supreme Court, in a case called Pakar Inc. against Competition Appeal Tribunal, ruled that where a third-party funder seeks a percentage of any damages recovered, the funding agreement qualifies as a damage-based agreement under UK legislation and is therefore potentially unenforceable unless it complies with certain other requirements of other UK legislation. And whilst that was a case about litigation, it raised a lot of questions around arbitration. So in other words, a lot of people thought the 25 Act was a perfect opportunity to clarify all of these issues for arbitration. They haven't been clarified, and it may be that there's an ongoing, I think, a report of the Civil Justice Council that's due to be issued, and it may well be that the government is waiting for that report before coming back with a comprehensive code or answer for third-party funding and arbitration. But that's where we are in the UK right now.
Thank you. Lucy, during the course of detailed deliberations before these 2025 rules were made, there must have been certain proposals which did not make it to the rules.
Right, a few things did go to the graveyard. A lot of small things, but I'll mention 4 significant proposals that did not end up in the final rules. The first involves emergency arbitration, which we've already been talking about. There was some pressure from the user community to lower the 14-day period for a decision in emergency arbitrator proceeding to 10 days. And the reaction to that was mixed, but we ultimately decided not to reduce the timeline because there was a strong group of users who said that 10 days would be too short for respondents to mount an adequate defense. And also there's really a lack of a real need to reduce the time frame to basically just over a week, given that the emergency arbitrator can and often does issue preliminary orders that protect certain interests over the course of the 14 days. And also, in reality, based on our experience, most of the emergency arbitrator cases get finished in far less than 14 days. The emergency arbitrator gets appointed very, very quickly and gets the parties together, and the decision comes out in under 14 days anyway. So we didn't change that, which I think makes probably a lot of respondents' counsel happy. A second has to do with publication of awards, and this goes in a sense to the overall identity and differences of SIAC from other institutions. The draft rules proposed a deemed amendment by the parties to publish a redacted award, commercial award, standard award, unless a party objected within 6 months after the arbitration was concluded. Right in the old rules, there was nothing on publication. So the proposal was the parties would be deemed to agree unless one party objected. And the feedback on this, I would say, was mixed. Some users were very happy with that idea. Others cautioned SIAC to remain aligned strongly with the principle of confidentiality in commercial arbitration and really protect the confidentiality obligations. We had a lot of discussions about this in the court, and we decided that, one, we would err on the side of caution and put in the rules that SIAC can publish a redacted decision or ruling or an order only with the written agreement of all parties and with the names and other identifying details redacted. This is what the Singapore courts do as well. And we think it's a strength for SIAC when other institutions are publishing regularly their awards in redacted form that we maintain the confidentiality of the users. I will mention, though, that under Rule 28.7, new Rule 28.7, we are publishing redacted decisions on arbitrator challenges. They're ready to be issued. We have about 15 or 16 we're issuing in the next body of time, because we think that the community can benefit from seeing what factors lead to a successful challenge of an arbitrator versus an unsuccessful challenge of an arbitrator. There'll be repetitive situations. The third, sort of less important, we floated in the draft rules the idea of the president, or if I can't do it, a vice president, using a list procedure whenever the responsibility falls on us to appoint a presiding arbitrator. In this case, it was the court members who recommended against using that, putting that list procedure in for appointment of the chair for two reasons. One, there's nothing to prevent the president from doing that if it's deemed appropriate in certain circumstances. And second, if we included that as the standard procedure for appointing a chair, then that would lead to the idea that it would always be used, and it's not always appropriate. It can cause delay, often, to go through a list procedure, which sometimes needs to go through 3 or 4 lists, and it might not work if we're looking for a specialist arbitrator as chair. And the fourth one was, the fourth proposal was that we would add an additional ground for consolidation of cases, and that would be, and I quote, a common question of law or fact arising out of or in connection with all the arbitrations, end quote. And here we got very strong feedback from users and advice from our court members to not do this because it's just too broad and too vague to get into a discussion of whether there's a common question of law or fact. So again, as I say, that went to the graveyard.
Thank you. Sudhanshu, can you tell us about your views on expedited procedure and the streamlined procedure that has been introduced in the rules?
Yes, so under the SIAC rules, there was already an expedited procedure requiring a decision on the arbitration to be made within 6 months. So under the new rules, the threshold for that procedure has been increased from 6 million Singapore dollars, so about 4.4 US million, to 10 million Singapore dollars, about 7.4 US. So that's the expedited procedure. There is now a new streamlined procedure, which in a nutshell requires a decision to be made within 3 months and applies to claims with a value below 1 million Singapore dollars. So all arbitrations are to be conducted by a sole arbitrator. The arbitrator must be nominated within 3 days of the notification that the streamlined procedure will apply. A case management conference to be held within 5 days after constitution of the tribunal. Default position, arbitration will be decided on the basis of written submissions alone, and documentary evidence, no documentary production requests, no fact or expert evidence to be filed, no hearing unless the tribunal determines there's to be a hearing. Reasons for the award will be in a summary form, and everything is done within 3 months. This is Virender Sehwag arbitration rather than Rahul Dravid arbitration, and there is a place for both of those batsmen in any team or in any arbitration regime. In terms of the impact, obviously where this procedure is adopted, there will be streamlined, cost-effective dispute resolution. Secondly, I can see it would be of particular value where the dispute is one of law. So, for example, a long-term contract, and it's the dispute about construction of a particular provision. I can see this being very valuable to allow the parties to rush off to the tribunal and get that issue resolved. I do have just a qualification, a third point to make, which is even low-value disputes can often, as we all know, still be complex. The fact that it's low value does not mean it's not factually complex. And I do wonder whether there are going to be cases where there are disputes of fact, where you have to see the other side's documents to get the answer. You want to lead with your own factual or expert evidence. I mean, shipping disputes are an obvious example where often the amount is under $1 million, but they're still factually complex. And whether in those kinds of cases parties would prefer not to go down this route and would prefer to exclude that option. So those are my comments.
Yeah.
Sorry to butt in again, but you're exactly right that there are situations where it would make no sense. And to date, we've had about 60 streamlined arbitrations. And the default is that anything under $1 million Singapore dollars will be go streamlined. But the other party, any party, can say we don't want to be in streamlined procedure because our case is too complicated, and that's a decision for me to make as the president. And there have been several instances where we've decided, no, that may be a small case, but that is not suitable for streamlined procedure. There's also an off-ramp where a case that starts in streamlined can get out of the streamlined procedure. But I want to say that the primary motivation for this true innovation of a streamlined procedure was really democracy. The idea that there are a lot of small cases where the fees are just too high to justify going to institutional arbitration. And I always highlight that one non-negotiable element of a streamlined procedure is that the institutional and arbitrator fees can be no greater than 50% of our pro rata fees. And I've been asked whether that applies if parties to a bigger case, and we're getting cases that are over $1 million where the parties are agreeing to streamlined procedure, do they also get that reduction in fees? And the answer is yes. And I've had some general counsel tell me that they want to put in their clauses that any disputes up to 5 or 6 million Singapore go streamlined because they see it as a way to quickly get rid of smaller disputes. Time will tell.
Thank you. What are your views on this expedited procedure as an in-house counsel? Not working, sorry.
So I think without going into the comments that Ella and Mr. Swaroop had made, while the threshold has increased, the procedure is more standard. I think it'll become a choice, of course, because anything that brings in efficiency with effectiveness is always welcomed by the disputing parties, by the in-house teams. I think one of the points I see is when you increase the threshold, the volume is expected to increase. The tribunals that are taking care of the more increased volume will have to align then with this workflow that comes in. I don't want to be in a position where more work comes in and then you have more backlog. I'm certain of it that the process and the procedure is already aligned. But this is one fact that as in-house, we would want to see how it turns out. With more volume going in, do I left behind? Will there be more extensions? I think time will tell. I'm very confident that the procedure is already already in place to manage this kind of increase, and that's how it would have been. But it's going to be very important to see time-sensitive disputes getting adjudicated, getting resolved in a quicker manner. And I think nothing better for a business to have the certainty of an outcome within a prescribed timeline, where they're absolutely sure that the procedure has been fair, as I said before as well. I think, therefore, it should become a very good choice, a fast lane for the disputing parties, and also a recommendation from a lot of in-house and general counsels as well.
Can you also deal with this digital case management in the rules?
Thanks. So from the idea of having the SIAC gateway as the go-to platform, I think it's very important also for us from an in-house perspective, because generally you have all the information technology protocols. You're not allowed to upload. You cannot have a software in your system unless it passes about 3 to 6 months of technology checks. It's a web-based platform, and I'm sure most of us are aware of it. But what it also does for us is we have a direct interface with what the filing is happening, how the procedure is going forward. There is no restriction of time zones or the physicality of things. And from our perspective, I think it also gives us a sense that sometimes certain presumptive delays which come into the picture because of the physicality of things will not happen. I think that's very important in a digital scenario now. Having all your documentation available at the back-end call of just few clicks and stored with security is one thing that would give us very, very big comfort, and the discussions with our external counsels will become more effective is our view. As in-house teams, we continuously leverage and are trying to find more tools like these to involve in our day-to-day operations. But having this on the dispute side of things with SIAC, I think that will also be one of the very good advantages that should help us as disputing parties or in-house counsels to leverage this technology and then get more efficient decision-making from our perspective. So, thank you.
Thank you. Ela, there is a strong emphasis on mediation in the 2025 rules. How significant is this portion? What does it mean for parties who may not traditionally see mediation as a part of international arbitration?
So the SIAC rule actually makes a shift by introducing the word mediation into the mainstream, giving it a push. There are two new provisions. So Rule 32 urges the arbitral tribunal to consult with parties at the first case management conference about the potential for settlement through amicable dispute resolution methods, such as mediation and MED-ARB-MED, which, Lucy, I know you're going to talk about next, so I won't go into the details. But it also allows the tribunal to suspend the proceedings while waiting for the MED-ARB-MED procedure to conclude. So there isn't going to be a delay in your process because parties are trying this sidetrack of mediation. You can do it parallelly. In any case, as you'll say, it's only 8 weeks they have, and they have to finish it. And as you said, sir, that there is a reluctance, especially I've seen with Indian parties, that mediation is just a waste of time. Either it's a process in a dispute clause which you have to tick off before you can get to arbitration, and people do it very functionally. But by putting a tribunal-led mediation, the consultation from a arbitrator who knows your case, I think it will give a push to parties to move, at least to try it out. And of course, if it works, there will be a lot of cost saving. I also wanted to point out that the Indian Arbitration Act, and I'm sorry to keep bringing it, but I just thought more interesting, already has this provision, Lucy, because our arbitrators are being told that we have to, under Section 30, Section 30, so it provides for the tribunal to encourage settlement through mediation, conciliation, and other procedures. And our draft rules which are coming out are going to drop conciliation and other procedures, I believe. That's a recommendation. So the push is going to be to mediation. And we have in India the Mediation Act, which allows for mediated agreements to be enforced. The one thing that we're missing is we don't allow for cross-border transatlantic mediated awards to be enforced in India. So a Singapore mediated agreement at this point cannot be enforced in India. So that's so Lucy's going to tell us.
Yeah. Though the Indian Arbitration Act asks the arbitrators to explore mediation and then encourage parties to go for mediation, which we normally do while doing arbitrations, Indian parties, in domestic arbitrations as well as international arbitrations. We see a cold response from the parties, and mediation is something which we cannot force parties to go. And in some cases where we send parties for mediation, they come back, like it's in court. So I think the mindset has to change, but it is very difficult. You're right in saying that.
Even the lawyers' mindsets have to change. Then they can push the parties to come to a settlement agreement.
Yes. Lucy, can you tell us about the ARB-MED-ARB protocol?
I'm happy to do that. I'll first confess, or I feel like I should confess or admit that I am a mediator and I'm a strong supporter of mediation. Looking back over my career and all the cases I've done as counsel or arbitrator, I think some percentage, I don't know, maybe 20 or 25, could have been mediated without the expense of taking it all the way through arbitration. Another 20% impossible, no reason to think about mediation. But I'm glad to see more focus on it. And I'll also tell you something a lot of you don't know, which is the difference between conciliation and mediation. Conciliation is a public international law process more than private, and in conciliation as compared to mediation, the conciliator is required to give his or her opinion on what a good and proper outcome would be, having listened to both parties' sides. Whereas in mediation, a mediator is not supposed to do that. A mediator is always supposed to make sure that whatever that settlement is, it comes from the parties. It's kind of a prehistoric sort of distinction that's very confusing. We have in Singapore the ARB-MED-ARB protocol, which can go into a dispute clause or be decided to be used after a dispute arises. And the way it works is the parties start in arbitration with an arbitrator or arbitration tribunal, and by agreement, they then will go to mediation with a mediator who's not one of the arbitrators. And at that point, one of three things can happen, really. The mediation will be successful, and the parties will sign a settlement agreement and report to the arbitration tribunal, you're not needed anymore. The two parties can come to a settlement and write their agreement and go back to the arbitral tribunal and ask for a consent award, an enforceable arbitral award that can be enforced anywhere in case one of the parties reneges on the settlement that's followed mediation. Or third, the parties cannot settle even with the help of the mediator, and they go back to the fight in arbitration. It's not a one-size-fits-all solution, but it does give, in the right cases, a chance for a settlement. We've had only about 50 ARB-MED-ARB cases between SIAC and the Singapore International Mediation Center. A good record of settlement, but not perfect by any means. 20 parties from 21 jurisdictions have used it, including India. I personally would like to see it used more often, because the general experience is if parties can be forced to try mediation, they can't be forced to settle. But often with a good mediator, in international cases, which take, I think, more skill than domestic cases, you can save a lot of time and money.
It was very difficult for me to frame questions in view of the number of amendments that have been made to the SIAC rules of 2025. I hope we have covered the important amendments that are made to the rules. We have another 8 minutes, so the panel can take questions. Can you please give a mic to him? You please identify yourself and you can ask the question.
My name is Ankit Malhotra. It's a question and also a cry. I'm not sure if there's any other way to classify what I'm going to ask. And perhaps what I'm going to ask is going to make it clear which chamber I'm from. It focuses on what Justice Rao said on emergency arbitrations and this case called Amazon. The emergency arbitration was successful, but it's only yesterday that Amazon is still being heard in the Indian courts. So the old adage perhaps is true. Operation successful, patient died. That's question one, or comment one. Second question is on third-party funding and in-house claims. I'm glad that the King's Counsel mentioned Ecuador. Philippe Sands' dissent there is instrumental. As in-house counsel, in claims where private investors are involved, and you have claims of the parties, how do you manage this? How do you reconcile this? And perhaps later on, if conciliation as only a public international law regime can be elaborated on, would be exciting. So in that sense, is the Pope's involvement in Argentina and other critical situations where there are, say, for instance, religious issues involved, the only area where conciliation can be used? Thank you.
I'll take a bit for the in-house part. I think one of the most important things from third-party fundings that happens at times is who has what interests in the matter and who are those third parties and what interest arrangements have been brought together. I think what SIAC does today is very many steps forward because in the new rules, you're not just asking who the parties are, you're also capable of asking what has been your arrangement and please disclose your interests as well. That changes the dynamics. Today, there could be very many, and for want of confidentiality also at times, I would not be able to comment how these are structured. But over a period of time, I think that will have to be seen that are these funders and the disputing parties being fair, not just to the institution, but the party against whom they are also going. Because it cannot be a situation that somebody bankrolls everything and then takes away. So those arrangements, as you talk about, yes, they will become very critical for any dispute where third parties get involved. And that will have to be seen, in my view, because this is still initial days of the SIAC rules and how the parties will take it back to the drawing board and then start deciding. And I'm very certain that the in-house teams will need a lot of help from the external counsels as well when they are structuring these now, henceforth. That would be my preliminary comments. I'm not sure whether I've answered it as you may have wanted, but I think, yes, everybody has to go back on the drawing table or across the board and think this through again. Thank you.
On the first question, you were asking me about Operation Successful, patient died. I don't think you're right fully there. As I was making my remark when we were dealing with this point, when it comes to an emergency arbitration where the seat is India, even an international arbitration which is seated in India, 17(2) is applicable and you can get it enforced. The only problem is with a foreign-seated emergency arbitration, what is it that you directly, it's not enforceable, and then you'll have to resort to filing a suit or filing an application under Section 9. So it's 50%. So patient is still there. Any other questions? Yes?
Yeah, my name is Sushil Shankar. I have a very short question for Ms. Reid. You said that SIAC intends to share redacted copies of challenges with the arbitration community. I'm sure that will be very useful to the arbitration committee. But what do you mean by the arbitration committee? Will it be in the public domain or is it only those related to SIAC in some way?
No, we'll post those on our website, and I expect they'll be published by this Monday or.
So it'll be open to everyone?
Wide publicity, yes.
Oh, thank you.
And I'll take this opportunity to say two other things we're working on, not as a change to the rules, but practice notes are for expedited arbitrations and for the streamlined, where we talk about a summary award, the arbitrators can issue a summary award. There's often a lot of reluctance by arbitrators to issue anything but a full-fledged, fully reasoned award, and that requires time. So we're going to, in a practice note, give templates and rules for how succinct a summary award can be, so that should help arbitrators be able to issue those more quickly without fear. And we're also considering right now a practice note urging arbitral tribunals to set page limits on submissions because of the overly repetitive and overly long submissions that many of us are seeing.
Any other question?
Good afternoon. My name is Nishtha Agarwal. I have the question for Ms. Reed. Ma'am, my question is with respect to the expedited procedure. Now, assuming that a party has opted for SIAC rule simpliciter, and one of the parties, they move for expedited procedure, which provides for a single arbitrator, whereas my arbitration clause was for 3-member arbitration. So now, will these parties be forced because one of the parties has moved, or do they have to consent? Both of them have to consent. So that was my question.
The answer is yes. Both parties will have to live with a sole arbitrator. And there's a rule that says if you adopt the SIAC rules, then if it's an expedited procedure, you will have one arbitrator. There was a Chinese case, court case, on this very same issue that you raised. So we've made that clear in the rules. But to be clear, when one party asks that an arbitration be expedited, again, it's a decision for the president to make whether it's appropriate for expedited procedure. And we hear from both parties on whether it's appropriate for expedited procedures. Unlike emergency arbitration, maybe 50 or 60% of the applications that a case be expedited are accepted and 50% are rejected, that the case is, they're listed criteria that's not suitable for expedited. And again, any expedited arbitrator can always shift the case back to a longer scheduled case if it proves necessary.
One last question.
Hello, I'm Saloni. Thank you for the insightful session. I have a question for Ms. Sheila and Ms. Lucy. So one of the initiation points of the SIAC rules are that they will be applicable to any arbitration post 1st Jan 2025, irrespective of if your arbitration agreement was entered prior to that. So suppose if the agreement was entered in 2017, and the agreement does not specify any addition, so it's broad to that extent. The parties wouldn't have been aware, say, in 2017 about, say, the PPO process, which is now envisaged. So I just wanted to understand how, in such a scenario, would party autonomy be reconciled, where the arbitration is starting post 1st Jan 2025, but the contract was signed prior to that?
I just want to, Lucy's going to explain that. But I am going to tell you, as a counsel, the problems that we face, because the first thing we do is when we open up the arbitration clause, some corporate lawyer has put in, we don't know, is he going to say it's the rules as they stand now, or is he going to give the date that the agreement was signed? It's complete confusion, and honestly, it makes such a difference. You quite rightly point out as to whether these provisions are applicable to us or not. And sometimes, as disputes lawyer, it may not, I mean, we find out ourselves whether we can go for PPO or not based on the way that clause is drafted.
I recognize, the confusion that you raised. The fact is that we had to decide one way or the other and be clear about the effective date of the new rules, and we opted for when the arbitration was filed rather than when the clause was written. But if both parties were to agree after the dispute arises that they want to use an earlier set of rules, we would respect that.
Thank you.
Thank you.
We are running out of time. I would like to conclude by saying that to improve is to change, and to be perfect is to change often, is what Winston Churchill said. We have the 7th edition of the SIAC rules which were made in 2025, which have been remarkable insofar as changes are concerned. And I'm sure that they're going to chart a new course in international arbitration. SIAC has about 30% of their work from India. Users from India are to the tune of about 29.28% as per the 2024 survey. We have a number of youngsters who are very bright, who are interested in making arbitration a career. They want to be arbitrators. They want to be counsel in arbitration. On behalf of the audience, may I request Lucy Reed, President of SIAC, to find if there are any programs where there can be training for youngsters in India after selecting them. And if you can encourage these youngsters, the landscape of arbitration in this country would change. That is the request I thought I would make to Lucy Reed as she is here.
We have training all day tomorrow.
Good.
Already, thank you.
Can you expand these trainings by taking them to the other parts of the country also, instead of only restricting them to Delhi and Bombay? Because we have such a large country and there are people who really want to get into arbitrations, but they do not have the avenues. That appears to be a problem. And number two, this is again for the youngsters. We keep hearing that India is not arbitration friendly. We keep hearing from our own leaders of the bar that India is not doing well in arbitration. India is doomed. India is a disaster in arbitration. Please don't believe all this. With the number of arbitrations that are coming up in India, and with the amount of interest that this event has generated in people from all over the world being here, that would show that arbitration is not going to die soon. It's not doomed. Forget about it. And it would definitely be much more interesting for youngsters if you can shed your litigation angle and then get into arbitration full time, like what lawyers in other countries do. I'm sure that you are as bright as people coming from the other countries, if not more. And I wish you all the best. Thank you, Lucy. Thank you, Ila. Thank you, Sudhanshu. And thank you, Prantap.
I am very grateful to the panel. May I request Honorable Mr. Justice Subramaniam Prasad, Judge of the Delhi High Court and Chair of the Organizing Committee, to felicitate the Chair and the esteemed speakers by presenting them with a Prabhavali. The Prabhavali is a traditional ornamental arch crafted in intricate brasswork symbolizing India's rich heritage of craftsmanship and cultural expression. Thank you very much. Thank you. May I request everyone to join us for lunch at the 6th floor and the deck area. Thank you.